या बढ़िया है, आप बताइए।
Okay, so we are live now.
ओके, ग्रेट।
We'll start this stream on time. Uh, we face some technical glitch and we have to switch to mobile phones for this stream. Uh, okay, so the stream is still unlisted. What we should do now? Uh, still unlisted. We have to share. We have to share the link. Huh? Oh, visibility is public. I think we should start receiving visitors now. If anyone is online, can you send us some message? We are not sure that we are fully live, or maybe we do not have any visitors.
या मनमीत जी is telling we are already live.
Yeah,
Let's
yeah, yeah.
wait for,
Now,
yeah.
yeah, couple of users started coming now. Ayush Somani is here, and Linus is here. Linus is here. Right. So we have live visitors now. Hello, Amit. Amit Gupta is here. Yeah, I think we have enough visitors to get the questions rolling and let the interview start. Or should we wait? What do you say?
Yeah, as you wish, it's fine.
Okay. We'll wait a couple of more minutes, then we'll start the
Okay, it's
question.
fine.
So, Ankur ji, we are doing this live stream after a long time.
Okay. Yeah, I saw there was with Mr. Makrani, there was some older video.
Yeah, that is
Yeah.
about 2 years ago. We have not done any
Okay,
live stream since then.
okay.
We have 18 concurrent viewers, and I think we should go now. So, how are you doing, sir?
Yeah, I'm doing good. Yeah, thank you.
Okay. Um, you are I was very excited about this live stream because it is happening after long time and
Right.
yeah, nothing, no such events have happened since the COVID, and everyone is excited to restart the DOMAINX uh, offline events. At least we are starting with an online event. We have a few concurrent viewers. None of them have said hi after Amit.
Okay, Manmeet ji is messaging that we should wait for another 5 minutes.
Mm. Yeah, we have waited for 5 minutes. If you are watching this live, please say hi if you have not done so. Domain investment is a very niche thing, so we do not expect a lot of viewers on these kind of videos.
Yes, of course.
है ना? I think we should just start. I'm very excited to do the interview.
Yeah, yeah,
Uh,
sure, sure.
it's very hard to wait even for 5 more minutes. And I think we have good viewership. We have 13 viewers online. So we just start with. I went through your profile on LinkedIn, and it's very impressive.
Okay.
What what does this degree means? You have dine at a buffet of education, right? Commerce, company secretary, cyber law, computer science. Uh, which one is your favorite?
Yeah, out of these, I did like initially, of course, the graduation is required. Then I did my company secretaryship, and it was followed by law degree, and then finally masters in computers. So out of the all, my favorite one is of course masters in computers. So
Mhm.
it helps me a lot in this field because in many of the cases you really need to have quite a good knowledge not only about online things, sometimes even about websites or how the websites are being designed. Sometimes you yourself have to design something or do something for evidence, or it helps overall.
Uh, what is a degree in what is a degree in cyber law?
So there are no as such degrees in cyber law. There are diplomas, or you can say certificate courses or diplomas. Because when anyone pursues a law degree, it's a normal bachelor's of law. So,
Okay.
and as on date, there is no university must be offering any specialized cyber law course as such, except that some are offering diplomas 1 year, like after you complete your bachelor's in law, then you can
Mhm.
pursue a 1 year diploma in cyber law. Or maybe
So
one
all
or
your
two,
degrees
very rare, someone is offering even master's degree. Yeah,
in cyber law.
yeah, in cyber law.
Yeah. So collectively, all your degrees collectively make you a expert in cyber laws, right? There is
Yeah, yeah,
no specific
right,
degree for that.
right, right,
And computer science is your favorite.
right, right.
So you have experience in both civil and criminal matters in cyber law, right?
Basically, I used to look into the criminal part as well, but there are always some practical difficulties in dealing with cyber crimes, you can say, because though you can fight cases for anyone trying to help them who have been a victim of cyber crime, but otherwise, as in cyber crime investigator, you cannot be that much successful because initially, if any crime has happened online, you may require an IP address that from where it has happened. So that
Mhm.
could proceed more smoothly through a police complaint. That police has the authority to obtain the exact details of the person who was using that IP address as on that date and time.
Mhm.
So that becomes a little difficult to deal with. So otherwise, I'm now mostly dealing in civil matters. Yeah, civil side of the law.
So you have practiced civil side of cyber laws for last 15, how many years?
Now 20 years. Yeah,
No, 20 years.
yeah,
Impressive.
yeah.
Yeah, you have studied computer science and then cyber law. Okay, what do you think domain laws are like s- straightforward like algorithms in computer science or something like that?
No, you can. We cannot say so because algorithm is a kind of a that follows strict logic of inputs and outputs, right?
Mm.
And there are predetermined results and so on. But in any kind of law, you will require some kind of judgment or interpretation of the law would be required, and there will be many different factual situations. Like in an algorithm, it will that these are the inputs, and so accordingly conditions are provided and output would be there. But in a law field or in any kind of law, there will be many precedents, many humans involved and many kind of different actions they have taken. So based upon the factual circumstances, a decision will come, and accordingly a panelist will act upon it.
So everything depends on a lot of factors, just like everything.
Yes, yes.
Uh,
Like to take an example, like normally in a UDRP, if a bad faith is proved, that if you had a knowledge of the trademark holder, you will be held. It should be a trans. If it is just a simple algorithm, it should result in the transfer of the domain name. Now, take
mm,
an example. There was a matter of buy sell empire.com. The complainant
mm,
in this matter was empireflippers.com. That is a famous marketplace for the selling of websites. So my client uh, did never as never denied the knowledge of the complainant, means he was aware of them, but still we were able to prevail in that because there are many different circumstances that are involved in any such matter.
mm. We will take these case studies a little bit later, and we will take
Yeah, yeah.
live questions from our audience after we take the case studies, right?
Yeah, yeah.
So you mentioned UDRP. What is the UDRP?
Yeah. So basically, a UDRP is a summary process that helps any trademark holder, because okay, let's come to the fact that it has a this domain name system and internet has a it is available globally. Fine. So basically, the UDRP helps in such cases like a trademark holder is located in a different country and the registrant is in a different country. So accordingly, now suppose Microsoft is based in US, or you can take an example of some other company which does not have a presence otherwise in India. So a trademark holder can file a cyber squatting complaints under the UDRP process to
Mhm.
claim right to a domain name that has been registered in violation of their rights, because Microsoft is such a strong trademark that I myself or anyone cannot register a domain name including a word Microsoft in normal
Mhm.
circumstances, that be- because it will be a case for cyber squatting. So UDRP mainly deals with such matters where someone may have registered a domain name and it may violate the rights of a third party. So
Mhm.
yeah, so there are few conditions that are required to be satisfied by a trademark holder. So firstly, they should have either a registered trademark, or otherwise they should be able to prove unregistered rights a in any brand or term you can say. And secondly, they need to show that the registrant does not have a legitimate rights in a domain name. And thirdly, bad faith should be proved. So if a complainant is able to prove all the three conditions, he can prevail in a UDRP proceedings against a domain name registrant.
Okay, and it has nothing to do with the prevailing law of that country of both the parties.
No, no, not essentially. Yeah, when it is parties are located in different countries, then it may not matter so much. But now, suppose both the parties are in the same country.
Mhm.
Suppose Tata is based in India and someone registers a domain name that is has a Tata as a keyword in the domain name. So the Tata company still has right to proceed against that person
Yeah.
in
Because
a
of this
civil court as
UDRP.
well. Yeah,
Yeah.
in a civil court as well, in addition to UDRP, because UDRP is
Okay,
always considered as a summary process.
so what I understand is that Tata has jurisdiction in India, but if someone thinks that he can live in Bhutan or a nation where Tata has not reached yet, and he can infringe their copyright trademarks and register domain names that contains the word Tata,
Yeah.
then what Tata can do, they can file a UDRP. So UDRP
Yes,
applies
yes.
everywhere as long as the domain is .com or any domain.
Means except for CCTLDs, normally UDRP applies. Yeah. Like even some CCTLDs like .pk for Pakistan, they have also adopted the UDRP policy.
Okay, so it depends.
It
In case
depends.
of
Yeah.
PCTLDs, it depends on the that country's laws, what they have
Yeah.
adopted. as
Yes,
their,
yes.
uh, for example, India has INDRP.
INDRP. Very right. Yeah.
So
Nixie
INDRP only
registry.
INDRP only applies for .in domains.
Yes, all the second level and third level domain names.
Means .in or
Yes, yes.
.co.in or
On
.net.in,
right.
org.in, etc. Right?
Yes, yes. Only.
Yeah, and these are the CCTLDs of India, and gov.in and edu.in are not publicly available. So these are the only
Yes.
ones that
Yeah,
we
yeah.
have to know.
Very
And
right. Yeah.
what is okay? You have been an arbitrator in NIXT,
Yeah, yeah.
so as well as UDRP panelist. So what is an arbitrator in this?
So similar to what one is regarded as a panelist in a UDRP process, similarly under the INDRP process, uh, a person who is presiding over the matter is called an arbitrator. That is mainly because Indian INDRP is not only governed by the INDRP policy but also the arbitration law of India. So so it works according to the Arbitration and Conciliation Act 1999. So that's why the person presiding is called an arbitrator.
Is it similar to a judge or a lawyer?
Similar to a judge, you can say. Yeah.
Okay. Now it makes more clear. And what is a panelist in UDRP?
Yeah, it's similar. It is also an
Similar as
arbitration
well.
process. That is also a simple arbitration process, but they call it as an panelist, a person who presides over the proceedings.
And you have been a URS examiner. What is a URS examiner? What is URS?
Yeah, so URS mainly came into being after the new GTLDs were launched. Like you must
Mhm.
be aware, as on date, there are so many new GTLDs like .club, .guru, right?
Mhm.
So it's a kind of a summary process, right? If a complainant can prove prima facie prove that there is infringement. Fine. So they can go under URS, and the remedy under URS is only suspension of the domain name. As against UDRP, that allows transfer of the domain name. Under
Okay.
URS, only the domain names will be suspended for the rest of the registration period. So that is the main difference. So
And what is the benefit of URS over UDRP?
it's a you will get a quicker decision.
Quicker decision and cheaper maybe.
Yeah, yeah, cheaper. Yeah, very right.
Yeah. So what laws apply to an Indian domain investor uh, when he registers, for example, a .com domain? So what all laws apply to? UDRP applies to him because it is a .com domain, and what other laws apply?
Yeah, so when you register a domain name, you accept the terms and condition of a domain name registrar. So
Mhm.
foremost thing, as you mentioned, UDRP or any domain name dispute policy would apply,
Mhm.
right? Then depending upon the jurisdiction, there are many different laws that can apply, like we made reference to the Tata thing. So
Mhm.
if both the parties are in a similar jurisdiction, then all the civil and criminal law will also apply because if you are in India under the trademark law, a Tata company can always go to the civil court and take an injunction under the trademark law that it's being in
Mhm.
violation of their trademark rights. Or you may have heard of many kind of scams happen, like someone may register a domain name that may have some name of some government authority. So
Mhm.
such matter are even taken by government under criminal laws. So
Oh,
in those cases, even criminal law can come into
impersonation.
picture. Yeah.
Okay. So Indian trademark laws apply and UDRP apply or INDRP depending on the extension of the domain.
Yes, yes.
And so can it also become a criminal matter? You give an example. If government is involved, it can become a criminal matter of impersonation. But
Yeah.
otherwise, can it be a criminal matter? For example, if I infringe Tata's trademark or Reliance trademark.
Yeah, under Indian Penal Code now, the law has changed under the Indian criminal laws. There are provisions of violation of trademark as well, but really anyone will go under the criminal law. But there are provisions for violation of trademark under the criminal law as well.
Okay, but I'm especially concerned about a novice domain investor who has not much of an idea of these laws, and by mistake he registers a very, say, very strong trademark like Google or Microsoft. So, what are the repercussions of that, and what he can do once he realizes that he's in trouble?
Yeah, it is really very important to understand that you should always avoid registration of at least of a well-known trademark.
Okay.
Though there is some kind of you can say, especially as to Meta, there was some controversy because uh, every domain name investor was aware that domain names having keyword Meta were very much in demand. It was, I suppose, in 21 or 22 before Facebook announced that they have changed their
Yeah,
name.
about 3 years back, maybe
Yeah, yeah,
21.
three. Yeah, yeah, yeah. So if anyone had registered such domain name before that date, before Facebook made any announcement,
Mm,
so till that time they were safe. But as soon as you are aware that some mark is well known and it belongs to a very well
mm,
a big organization, so it's better to avoid them. And also, what I have recently experienced with a domain name investor, he had registered this Meta domain only,
mm.
but but it was after Facebook had already announced its change in the company name, right? So initially the company gave him a cease and desist letter, but he did not respond. Fine, but later they filed a UDRP against him. And then when he wanted to surrender the domain name, the complainant said, "No, no, we do not want any kind of settlement, even for free. We do not want the domain name. We will get the domain name only through the proper process of UDRP proceeding, because we have already made all the efforts. We tried to contact you, but you did not respond. Now we will go through these proceedings." So it's better to avoid, because now if once your name goes in any such proceedings as a cyber squatter, because if it is a well-known mark, you will be labeled as a cyber squatter. So this may always go against you in any future UDRP proceedings, because even if in any future proceeding, another complainant may always make reference to the older UDRP matter that you were already involved in that matter. So even that another domain name that you have registered, it can some presumption could be there that it may also be in bad faith.
Okay, once an offender, always an offender kind of
Yeah,
psychology.
yeah. So it's very important to avoid any such
Yeah, the
registration.
punishment if you are an offender in UDRP case.
No, there's no provision of a penalty
Okay,
under UDRP. There will always be only a transfer of the domain name. But
okay,
as against INDRP, there is provision for cost. So in under INDRP, they sometimes some arbitrators do avoid some costs. It could be some legal costs. Otherwise, there used to be some arbitrator in early 2010 to 2015. He used to avoid rupees 10 lakh in every decision. I am not sure why, but it was really something really strange. Yeah,
so there is no penalty, but your name will be publicly available in all the uh, what do you call them,
yeah,
decisions, right? In
yeah,
all the
yeah.
decisions of the past, and you will
Very
be
right,
quoted for a past decision that you have done this before, and your future cases will become weaker.
right,
Um,
right.
okay. Uh, if someone owns a domain name for a long time, and then a company files a trademark, and it's a very large company, so trademark is suddenly becomes very strong trademark in couple of years, like Meta did. It has been only 3 years, but now Meta is almost a property of that company,
Hmm.
the keyword Meta. So what happens in these cases?
No, in these cases, if you are a prior registered, you have prior registered domain name, you are quite safe. Now, just take an example of we have Mr. Rodney Ryder in our group. He had already named his law firm as Meta Sept many years back, maybe 10 to 15 years back. So
Okay.
now the Facebook can never challenge him, because otherwise meta is a dictionary word. So any such person who had already named adopted a brand name based upon a future trademark, then he is always protected. Unless and until it was a very close matter, like someone had uh, some through news or any source he knew that something is going to happen in near future, or
Mhm.
even some I have observed some Chinese people I have observed what they do is they register a domain name. They are aware that as and when some trademark application is filed in at USPTO, I am not sure how they track it, but I have matched the dates that they had some matter, UDRP matter, and the exact date that person filed registered domain name was the exact date when the trademark application was filed in USPTO. Though the trademark may have been granted after 2 3 years, but on that date he became aware and he registered domain name. So this will become a matter of bad faith, as long as that is a distinctive word or a distinctive combination, not a common phrase. So that will be a violation.
Right. So you are innocent because you cannot know about future trademark, right?
Right,
Right.
right.
But what happens when the domain is already registered, but you buy it after the trademark is very clearly established?
Okay.
Like in the case of Meta, what happens if I buy a domain which contains the word Meta from
Yeah.
other investors who have held it for like 20 years or 15 years? What
Mhm.
happens in this case?
Okay. If you are a, subsequent buyer and it was after that date, like in 2023 or 2024, then still you will be liable because because you had knowledge as on date when you acquired the domain name for the purpose of UDRP. That date will be considered as a date on which you became the owner, though it was through transfer. So it will be considered as a violation unless and
But
until you have very different use to it. Yeah.
okay, but original registrant had some rights, na? Right. He did not trademark his domain. I think domains cannot be trademarked, but he hold this domain for like several years. Can't he sell it off for some profit?
Yeah. Yes. See, if Meta will go, it will not. They will not be able to go against the original registrant. Fine.
Hmm.
He has a right. He can hold it because, in addition to the example I gave, even once I replied to even a legal notice that was received from Meta, and my client was holding a domain name that had a prior registration, and we just responded to the legal notice, and they never came back. So he has right to keep the domain name and even sell it. But if another person is acquiring the domain name, and if Meta decides to come after the second, who is the buyer of the domain name, then there could be an issue. If it is quite, say, similar to any product they are running or already it's popular,
My my
so it
question is
depends.
if my question is if the buyer cannot buy it, right?
Yeah.
Because now the trademark exists, then seller can't sell it. And if seller can't sell it, what is the what did he do wrong by holding that domain for 20 years and now he cannot make money out of it?
Yeah, no, it will again depend what is the use, because if the buyer has a very different use from what Meta is into, then of course it will be open for sale. But of course, no one will acquire it for further resale. Only a legitimate user will acquire such a domain name.
But there cannot be any legitimate use after meta trademark is deeply uh,
No, you cannot say so, because if say some domain name is only Meta something, and
uh,
they are not going into technology, some very different uses there. If they have some kind of explanation, they can
hmm. Okay.
always see to it. Yeah.
So you have a very hot take about that domain investors should not list their domains for sale. Why is that? What is the consequences of listing a domain for sale?
No, as on date, it is not so. Previously, you can say. uh, till 2015-16 year, issues were there that people used to keep this under covers. You can say that they were not disclosing openly that they are a domain name investor. But since 2017 or even earlier, but since 2017 and later, there are more and more judgments that provide some a kind of protection to the domain name investors.
Oh,
Even there is a WIPO overview. There is a document created by WIPO that is called WIPO overview that contains a summary of the uh, judgments that are passed by UDRP over the years. So even there is a clause that very clearly says that holding domain name for the purpose of resale as on date, it is a legitimate activity. So
okay.
as long as you are holding uh, a portfolio of domain name and it
Mhm.
the purpose could be only for sale, so that is fine. It is considered as legitimate activity and you get even protection under the clause 2, that is legitimate interest. Only the
Okay.
issue that can come is when you have parked the domain name, there are some infringing links or reference to the trademark holder. Like on Sedo, it happens if you have a Sedo parking page, there
Mhm.
will be buy no option, but in addition, there will be links or some reference to the competitor websites would be there. So that can only land you into trouble, not a simple for sale pages like on dan.com.
Okay, so if someone has a domain which may be potentially infringing some other company, then he should not put ads on his landing pages. Is that
Yeah,
correct?
yes, yes. So what happens? Yes, because always whatever the keyword, if it is a common phrase, but it may happen that someone in some part of the world is holding trademark rights in that
Mm,
phrase, even if it is a common phrase. So whenever some such links appear, the links will never make reference to a dictionary meaning of that term, but those will always be commercial links because someone will pay for the advertisement there. So chances are very high that you may not earn that much from the parking revenue. Then you may end up losing the domain name in a
or
UDRP
maybe the other
proceedings.
party deliberately pay for advertising on your domain. They can do it. You do not have control on the ads, right?
Yes, very right, very right. Yeah, because it may happen because if say ads are sourced from Google Ads and the other party is already paying to the Google for their advertisement, so of course those ads will surely appear on your parking page.
Okay. So why do large corporations need to protect their domain names, even those which they are not going to use anyways?
Yeah, because these days, normally, but though first of all, after the launch of new GTLDs, we can say it has become a kind of impossible to register and hold any and every kind of extension. But
Yeah.
yes, in many of the cases, like for important extensions like .com, .co, .net, .org, maybe 4 5 extensions, major extension, or maybe some new GTLDs that may be more relevant to them, they can always hold. But in addition, whenever they file for UDRP, and there are many kind of infringements, like I sometimes handle matter for trademark holders. So mostly the complaints that we file that may relate to that a similar domain that could be a you can say a kind of spelling, one or letter have been interchanged or some letter has been added to the domain and they are being used either for phishing activities commonly or a website is there that they are through which they are trying to sell some like in case of pharmacies we can say without license some duplicate medicines or duplicate products are being sold. So in those cases, then they have to get the transfer of domain name even under UDRP and hold it for some time at least.
Hmm. So since they cannot keep an eye on all the domains and all the variations and combinations, They just don't want anyone to register them, and if someone does so, they just come after him.
Right.
Okay. Are there any fair use cases when someone may own a trademark infringing domain? Are there any fair use cases for that?
Yes. Uh, recent, recently only I had a matter. It was an year back in 2023. My client had a domain name netflixstories.com. Fine.
Okay.
So no one can deny that he has no knowledge of Netflix. Fine.
Mhm.
So this matter was filed before NAF. So my client was mainly that story writer, uh, that is with Guild. There's an organization in US, I think Guild Awards or something. There he was a screenwriter. Those days, these people, all screenwriters and everyone was on strike. If you are aware, in 2023. So
Mhm.
during that period, he had registered his domain name, and his uh, intention was to put some stories from all the people that were in his association, because there was some kind of things that are happening at Netflix, and he wanted that it should come into light. So it is such things fall under the a fair use of the domain name, a kind of fair use it is. So we had filed a response, and there was no decision, but the Netflix people withdrew the complaint, and the domain name is still active, and it is with my client. So this is one of the example. Then in addition, if a domain name contains, you can say, a celebrity name,
Mhm.
and a kind of fan site is run on the domain name, then those kind of also domain names get some protection. So come if they fall under the kind of a fair use of the domain name, fair use, or
And I've
sometimes
seen,
in free speech.
and
Yeah,
I've seen some critics websites, and they are more common compared to fan things. For example,
right.
PayPalSucks.org, or I think PayPalSucks.org, the website is.
Yeah,
So
many are there. Even for Disney, even in this Netflix, my client even gave example like Disney Examiner and many domain name that use the trademark Disney, and they are quite active websites. So yeah, many kind of either they are providing just information, or you have critics, as you can say. Even at Netflix story, my client wanted to be a little critical of Netflix, but
does,
still
does the
give,
fair use definition come directly from the DMCA Act?
not exactly. So
Okay.
that fair use is more related to something that is copyrighted. You are
Hmm.
making a fair use of something, some content
Copyrighted.
that is copyrighted, or a clip or a music,
Hmm.
something like that. But this fair use could be that you are not making a harm to the, or targeting a trademark in some negative way. The
Okay.
word sucks that you said, that may still not be allowed. They see that it should not be very negative word that is also harming the reputation of the organization.
I think that website is PayPalSucks.com or org.
Okay,
But
because
okay,
sucks
let's
kind
move
of
to, yeah.
many
And it's
matters
very,
that
very,
use.
that website is as old as PayPal. I can say that.
Okay, okay,
And
okay,
they have many
fine.
users, and it is very popular.
Right,
Okay.
right.
So let's move to the next question.
Yeah.
Uh, okay. What is different between a registered trademark and an unregistered trademark? A lot of people have this question.
Yeah, so mainly in a UDRP proceeding or even INDRP, it is a standing requirement. If you have either a registered trademark, or you can prove rights in an unregistered trademark, only then you can file a complaint.
Okay.
Because as an even as an individual, or say a very person who has an SME, he just started his business say a
Mhm.
month back, and someone registered a domain name similar to his name, so that organization or SME will not be able to take action in an UDRP proceedings. Why? Firstly, because not only that they do not have any trademark rights, but
Mhm.
also because of the use for only last 1 or 2 months, they won't be able to prove unregistered rights, that is called the common law rights, in a UDRP proceedings. Like
mm,
if you do not have a registered rights, but if you are able to prove through the use of the trademark that you have done for the last many years, that could be in the form of advertisement, sales revenue under the mark, or any consumer surveys, or any other kind of say social media accounts are there that are good number of followers, many kind of things you can show to prove that you are using this brand, though it is not registered, but you have common law rights in that brand because you are using it on a large scale. So that all falls under the unregistered rights
yeah,
you are able
suppose
to
suppose
prove.
for example, a newspaper runs a daily column, and that daily column name have become popular, and for like 10, 15 years they are using that name, but they've never
Right,
bothered to register it as a trademark, but it
right.
is still considered as an unregistered trademark
Yes, yes. Yeah, they will
because
be able
everyone
to
knows that.
common law rights.
Yeah,
Yeah,
because everyone knows that that column belongs to that newspaper.
yeah. So the evidence they can provide is the number of newspaper that they have sold over the last so many years. So
Hmm.
that means it is publicly well known. So they will be very easily able to
They
prove
have
the
to
common
prove
law
it was
rights.
publicly well known.
Yes, yes, yeah.
Okay.
Known to the
So,
public.
does date of registration matter a lot? Because as a domain registrant, I cannot check all the trademarks and things like that. Uh, does if I'm delayed by 1 or 2 days, or does it matter a lot in the court?
Can you come again on this question? Means
My
how the
question,
risk?
my
Yeah,
question is: suppose I have registered a domain, and
right.
just before that date, the trademark was filed.
Fine,
I was not aware of that because
fine,
filing of a trademark is not a very newsworthy thing, right?
fine.
So
Right,
I did not come to that news. I did not heard about that news, and I registered the domain. What
right.
happens in these cases? How can I prove that I did not know about the trademark?
So, of course, this will require a kind of good explanation, a logical explanation. Like if it is contained of say, common name or common phrase, a dictionary word, then always you can show that the purpose of registration was either domain name investing, or you have some plans for a business for which you have already taken some demonstrable
Hmm.
steps you are going to pursue for the for setting up business, or
Hmm.
as long as it is not as distinctive, like if someone had just applied for a trademark and it is quite distinctive that
Hmm.
it cannot be proved, you cannot prove it that you could independently come come up with these terms.
So same idea.
Yeah, exactly same terms.
Hmm.
Like Hero Honda is their combination. You if you
Yeah,
register,
all the made up words, right?
yeah, yeah, yeah. Even
Okay.
Hero, or you can take
So it's okay
more
to
example,
register
Star
domain.
Plus.
Yeah, it's okay to not worry about trademark or the date of registration of trademark, as long
Yeah.
as your domains are very generic and they contains the normal English keywords.
Yes, yes, very right. And
Right?
yes,
Because
that will be done.
when I went to the WIPO website and looked for the keywords like all the English words, I think every English word is trademark. No English word is no proper noun is not trademark. I think so.
Yeah,
So
very right.
yeah,
That
I
is so
registered a
as
domain
on deal.
physics.app because I like the word physics. Right, it's a
Mhm.
subject name. But that was trademark at least 100 times in the WIPO website. So
Right.
even a word like physics can be trademarked for 100 times, then nothing is spared, I think.
Yes, of course, because in any unrelated category, like if it is class 5 that relates to medicine, I may register word computer for a medicine. Now, computer, otherwise, it's a common word, but in a very unrelated class, that is medicine, I can sell a medicine under the name computer and it can be allowed. Because as long as a common word is not describing the goods or services it may cover, so it is allowed under the trademark law.
Yeah, so trademark has 35 categories.
No,
but the domain
45.
is just one.
Yeah.
So you can say that my belong to any other category
Yes, that is
as long
also
as it
there.
is done.
Yeah, yeah, yes, yes, yeah.
Okay, what other due diligence should a domain investor take? For example, suppose I am a new domain investor, so I will check for trademarks. I will check for what due diligence should I take?
So I think the simplest thing you can do is you are going at a very advanced stage that you are going at the WIPO website and checking the global world trademark database.
No, I just
But
searched Google for trademark database and I found WIPO.
okay, okay. Because till date we haven't come across any UDRP decision where the trademark holder has argued that it was your duty to search WIPO global trademark database. But at the
Hmm.
most, they suggest that you should have been aware of the registered trademark. And we always take a defense that if I am in a different country, I am not supposed to check the trademark database of that particular country where the complainant has an establishment, right? So otherwise, coming to the due diligence part, so if you can
Trademark is
just,
one.
yeah, trademark is there. So if you look at the, like if you are in India, you can just look at the trademark registry website for trademark that there is no trademark in India. So that is
Hmm.
also good enough. Though it
Okay.
would be difficult because you need to provide a class, so you can go to some other website where you may get for a single keyword uh, all the search results for different classes. But trademark is one, then Google search is there second. So Google search is quite important these days because it's quite simple to use that anyone can do a Google search, because in many cases it happens in many UDRP decisions it is now been uh, in the judgment says that at least you should have done a Google search. Like I remember a matter of AOGA.com.
Hmm.
So this was a matter under UDRP. AOGA is a some oil-based oil exploration company based in Alaska, USA. Right.
Hmm.
So the person who registered a domain name, he had bought this domain name from a prior registrant, but he had no idea that this domain name was stolen one. The prior registrant had stolen this domain name and sold to this person. So
Hmm.
his argument was under UDRP that he had no idea that this was a stolen domain name, and he thought it was a only four-letter domain name, and four-letter .com are quite valuable under as a domain name investing. But
Hmm.
the panelists reached the conclusion that at least you should have done a Google search and you would have been made aware that this is a well-known oil exploration company, though based in a different part of the world. So it is important if to at least do Google search to see that that word is not being used on a large scale. So that is important.
Google search will also pull up all the unregistered trademarks, right?
Yeah, but still you get an idea. See, one important thing is if you search for a term, there's a single organization using that term, then that is a trouble. But if there
Hmm.
are hundreds of organizations using the same term, then
Hmm.
it is fine. That also helps you
Why it helps us?
because a wide third party use of any phrase means that that word is not exclusive to a single trademark holder. Fine. Now, suppose you take
So
any term
how
like,
does non-exclusivity help the domain investor?
see, like Netflix. If you
Hmm.
search for Netflix, you will only get a reference to a single organization. There is no other user of the
Right.
this word Netflix, right? It is quite distinctive. So it's a quite a good indicator that it is exclusive to some organization, right?
Hmm.
Now you want to adopt an organization name as like Silo. I have my firm name as Silo, Cylaw. But
Hmm.
Silo is also short for Law of Cyprus, Cyprus law. Fine. then I am using Cylaw. Someone is using Cyberlaw, short for Cyberlaw as Cylaw. So there
Mhm.
could be many users. So it depends. From such lens, you can go through all these factors, that how exclusive it is to someone, or you could otherwise independently come of a combination or an acronym for a different purpose that will always safeguard you.
Okay. Okay. So we have covered uh, the due diligence part of a domain investor. We should check for the registered trademarks. We can also do a Google search. We also have to see if the domain was stolen. That is also part of due diligence. After that, we can list it for sale without ads. It's good. We can if without ads, then we are more protected.
Yeah.
Okay.
Yeah, it's a only landing page for sale. It is quite safe these days. There are lot of UDRP decisions that help. Yeah.
So, okay, there's a viewer question. Suppose we have registered a domain, we like the name, and it is quite unique for us, and we have registered it for quite some time, like 15 years, but we have not started anything on it. Does that 15 years or 20 years of holding that domain bring us some rights on that name, and we do not need to trademark that name anymore? Or
Yeah. If you are, it means such kind of holding is called under UDRP passive holding of the domain name. So
Mhm.
under UDRP, it is quite fine that you are holding a domain name for last many years and only have put up the domain name for sale, or even you are not doing anything. It's quite fine. Like previously, I had matter of VGW.com for a South Korean domain name investor. He's holding the domain name since 2002. That is 23 years, and he has just a landing page of the domain name. He otherwise has not made any use of the domain name. So it's quite fine.
no, I'm asking that.
Only, yeah,
Does that invoke some trademark of our own, kind
no,
of
no,
unregistered trademark,
no. That will not provide you with any
because
rights.
we are
Yeah,
not
unless
using that domain yet?
yeah, because you are not using. If you had used that in any some kind of business or anywhere, like used it for branding or any kind of for branding any products or services, then you can claim rights.
Okay, what happens when someone, a domain investor, receives a UDRP email? Do I need a
Yeah,
lawyer?
see, what I have experienced is, of course, if you can provide a response, you can always do. But in few cases, what we have done is like some of the a good domain name investor had received a few of such notices. So what we do is we reply to the trademark holder in detail to that legal notice, including some UDRP precedent. So that gives an idea to the trademark holder that this domain name investor is already prepared in case some UDRP proceedings come. So in such circumstances, we have never seen that that trademark holder has later come in a UDRP proceedings, because if you are not ignoring the notice, that is also important. You are responding to it and responding in much detail that may otherwise we may respond in a UDRP proceeding, like by making references that I am a domain investor under law. These are the precedent which provide us a protection, and even putting the domain name for sale, and additionally that the reason that you register domain name as it is contains comprised of a common phrase or dictionary word or is a geographical term. So all such explanation helps you a lot, because
Hmm.
initially you may, even if you hire a lawyer, you will have just to pay just a little bit consultancy. But if you go later under UDRP, then you will have to pay more. So it's better uh, to avoid the situation beforehand. Like even I gave you an example initially that someone had otherwise ignored a legal notice. So later it was Meta company. So they even denied later that we will now not uh, terminate these proceedings, but go on with these proceedings because we are already informed, served a notice, but the registrant did not respond on an earlier occasion.
Is it compulsory for the trademark holder to give a prior notice before filing the UDRP?
No, no. Though,
They can just
yeah, they can just
okay.
proceed with
Straight
it
to
just to
the
save their cause. They may sometimes serve you with a legal notice that maybe they can pressurize you to get a transfer or a domain name. So they may have different reason to serve you with a notice. But otherwise, there is no legal requirement.
So AI is changing all the industries. What is the effect of AI in the UDRP cases and
Yeah,
UDRP
so
complaints?
so recently I am already dealing with a matter. I will not name the matter or what domain name
Okay.
it is, but I am seeing what a trademark holder has done is they are firstly they are trying to make argument based upon AI. So when you are making arguments based upon AI, AI just is providing you some pointers that these you can argue, but that layman is not understanding that he or she is arguing on such grounds that do not exist. Like in that matter, uh,
Hallucinations.
they try to join two respondents in a single complaint, though the UDRP says that you can file a single matter only against the same one respondent or only when the same respondent owns more than one domain name. Otherwise, they need to file different complaints,
Hmm.
respective complaints against the domain holders. So here the person just picked up all the argument that could have been applied from AI, and not only this, then there are AI generated some kind of chat is there that I chatted with this celebrity, and it is quite obvious that it is being generated through AI. So there are many kind of manipulations that are happening with the help of AI that these complainants try to make in order to prove that they are popular or they have rights in then unregistered trademark. Like even some banners are there, some website screenshots are even there, but website no URL of the website is there, no evidence is there that any such website exists. So some misuse of AI is being done even by complainants to harass domain name investors.
Okay. So AI may take millions of jobs, but yours is not one of them.
Yeah.
Okay.
Because you can argue based upon AI, but unless you understand that what you are arguing, you have no knowledge. So if you are a layman, then we can very easily counter those.
Okay. We have crossed 1 hour. In next 30 minutes, we'll uh, go through a few case studies which you have recently concluded, and we'll also take viewer questions. Okay, so everyone is excited about geohotstar.com, though you have put your views on it in the group earlier also. But let's take this example. Everyone is interested in it. Uh, so geohotstar.com never went to court. Geo never went to the court, but they still get the domain very easily. Why?
Yeah, hello.
Yeah. So
Yeah.
why the owner of that domain had to give that domain away to geo.com?
See, like we already referred to some law situations, like if the domain name is composed of strong trademarks like Geo and Hotstar, though it may not have been registered as a trademark in a combined form, but Geo or Hotstar independently are well-known trademarks, right?
Okay.
So no one can claim that they came up with this term independently without any knowledge of the trademark holder or that
Hmm.
they have any future plans related to the domain name or any venture is going to happen. Like
Hmm.
this person initially at its website stated that he bought this domain name in speculation that this may have happened.
Yeah,
But
that's one.
yeah, and the registration date of this domain name was 20th September 2023, And if you Google for any news item related to this venture that was going to happen in future, the news are dated 18th or 19th September 2023. That was a day or 2 days before this person registered a domain name. So it was quite obvious that he had registered the domain name with complete knowledge of the trademark holder and the venture they are going to enter into near future. So he just wanted to have take advantage of this future venture, and or maybe an intention to make some money by making sale of this domain name to the trademark holder. He expected maybe they may require this domain name, and it's such a big organization, so they may offer him some
Hmm.
consideration. Yeah.
But
So
that was
that
bad thing.
yeah, so that's why it was a totally a bad faith action that can never sustain. So that is why this matter never went to the court, because though initially they were acting quite confident that no, we can keep this domain name forever and nothing will happen to us.
People need to
We are
worry.
quite safe. So there were many comments, many tweets were
Yeah, he
there.
mentioned that
Even
he had got some legal advice. That was
yeah,
surely a bad advice.
they were even referring that we have got legal advice, nothing can happen to us. So even a lawyer made a post that I will fight for you for
Hmm.
free to protect this domain name. So it was not feasible. You can't
But
fight.
that was a case where he did not actually speculate, but worked on, acted upon actual news or rumor,
Right,
you can say. But
right.
what happens if I actually speculate? For example, let's say I registered today geosteelplant.com or geosteelmanufacturer.com. Do not work in the steel industry, but in future they may work in the steel industry. I'm using the trademark word geo in that, but that geo steel is not a trademark. What happens in that case?
You will still be, you will have to hand over the domain name
Okay.
ultimately, because I'll just give you an example. There was a matter of this oyolife.com
Mm,
in 2019.
mm,
So Oyo was already well-known brand, but they were initially using for this part of their business, the name they were using was Oyo Living, right?
mm,
But later they rebranded their business to Oyo Life, but this domain name was with a South India based domain name investor. So Oyo people had come under UDRP for this domain name. So finally, it was decided that this domain name cannot be independently used in any in non-infringing form. Means whatever way anyone would try to use this domain name, it will be a kind of infringement, because Oyo is such a famous brand. So similarly, in this case, Geo is so famous that even as on date they are not in this field, but otherwise, we have never heard that GIO, this kind of uh, brand being there in India. So it will be
mm.
quite difficult to show kind of ignorance that we were not aware of the Geo trademark or Geo brand. So that is the issue.
Okay. What was your
Yeah.
most recent UDRP case that you handled?
Yeah, the most recent one was kmine.com. That is
Mm,
KMINE.com.
mm,
So my client was UK based. So I just got this decision last week in favor of my client. So in this matter, uh, the complainant company was is using the domain name k-mine.com. Means
mm.
hyphen is there. So obviously they wanted an
You
upgrade
were
domain name.
representing the domain owner.
Yeah, I was representing the domain registrant
Mm,
owner. Yeah. So they mainly wanted to upgrade to the domain name for which they filed this UDRP.
mm,
But this was not a kind of domain name investment. But even if it was a domain name investment, my client said that he adopted these keywords because K-mine otherwise means knowledge mine.
mm,
It's short for knowledge mine.
mm,
So, and even as on date, under AI, this field is more. terminology is more frequently used. So even if you had such domain name as a domain name investor, you were still protected. But in my client's case, he was having a company name as KMine Info Solutions Private Limited in India since 2013. So that's why he was already protected under the legitimate interest that he was commonly known by the domain name. So
And
we
when was
got
the
this in
decision
this way.
come out?
It was in only in this 6th or 7th January.
Oh, very recent.
Yeah, 10 days back.
Okay. Any other cases you handled recently in 2025?
Not 2025, but in 2024, I had few
Mm,
matters for domain name investors. Like one was gonzo.com. In
mm,
gonzo.com, Gonzo was a German company, their trademark holder that came after this domain name gonzo.com. Gonzo is
mm,
otherwise a last name for many individuals all around the world. So you can say it is based upon the last name. And my client was holding this domain name since 2011. Though
mm,
this German company claimed that they are in existence since 1929 and already had a trademark since 1990s or even I think before that. But what happened was that my client never approached them for the sale of the domain name. He was always just keeping this domain name for sale on a landing page on his website domainshop.com. So my client
mm,
otherwise has this website domainshop.com there where he has already listed 5,000 domain names for sale. So gonzo.com is one of those domain names that is for sale at 24,500 USD. So these people had approached him in the year 2020, but my client at that time also quoted this price, but after that they never came back and uh, not even served any notice like we were discussing. They just straight away came to this UDRP proceedings, and we were able to save him under the that clause that is the Plan B, because under UDRP, when a complainant has already tried to approach you and tried to uh, ask to buy the domain name, and later he comes under UDRP because he is unsuccessful, so that is called a kind of a Plan B under UDRP. So, so even though they were a prior trademark holder based in Germany, my client was in US, so he still got an RDNS decision in this matter.
yeah.
Uh,
RDN.
Yeah.
What is exactly reverse domain hijacking?
Yeah, so reverse, we can get a domain name registrant mainly can get a RDNS decision against a trademark holder if he can prove that the complainant brought this complaint in bad faith, right?
So
Like,
it is only followed by a after a UDRP.
yes, only if a registrant is successful, then he can pray for the
Mm,
RDNS decision. So, normally an RDNS decision will be pronounced in matters where uh, this registrant is a prior trademark holder, like a trademark in VGW.com case I was referring to, that
mm,
was with a South Korean domain name investor. So he is holding the domain name since 2002. And that's
mm,
VGW company that is on vgw.co. They are using Australian company.
mm,
I think they came into existence around 2010 and had a website around 2015 or 16. So when they are coming after a domain name and they are aware that they need to prove both the conditions under UDRP, a bad faith registration and also bad faith use. So when a domain name was priorly registered, has a prior date than a registration of a trademark, so
mm,
such matter will mostly fall under the clause of RDNH. Means you can
mm.
always prove that they came under these proceedings under
Bad.
in bad faith because they should have been aware. Mostly when they are representative by an IP lawyer, so you can more argue that they are not a layman. They are aware about the provisions. So they should not have filed this UDRP because even for a resistant, he has to spend money in hiring a lawyer or making responses, take
Mm.
out time and spend resources in defending a domain name. So on these basis, we can always argue for RDNH in a UDRP
What happens if
proceedings.
you win an RDNH? Is there any
Pardon?
punishment to the party?
No, no. It is just that it gives a bad reputation to the complainant. You can say it is more stronger decision
Hmm.
against the trademark holder because they had no right to come under the UDRP proceeding. It's a kind of warning that you should have
Okay.
thought about it before
Just a
filing this
warning.
complaint. Yeah.
It's just a warning.
Yes, yes.
But I suppose that it can be used in the future if he tries to go after another domain name through UDRP.
Yes, it can work. Like we took an example that against a registrant, it can work that you were in a previous UDRP proceeding, there was transfer in your name, so you were
Hmm.
cyber squatting on a brand name. Similarly, we can
Hmm.
always argue that the complainant is in the habit of filing such
Hmm.
complaints in which should not have been filed, but they are coming to this forum in a bad faith.
Hmm. What is the most against the odds or the most surprising UDRP decision that you have uh, consulted in as a
Yeah,
domain lawyer?
yeah. Recently, also, when this Gonzo happened, just a month before or after it, there was a matter of onetab.com.
Hmm.
If you know of there's a Chrome, well-known Chrome extension, OneTab,
Okay.
ONETAB, right? So they are
Hmm.
using, again, they were using the domain name with an hyphen, hyphen
Hmm.
tab.com, right? So they came after this domain names, OneTab. So OneTab, they, their extension was launched in the year 2013, right?
Hmm.
And my client registered a domain name on 2nd or 3rd March 2023. That
Hmm.
is 10 years after that extension came into existence. But
Hmm.
those people registered the trademark in 2024 only. But in this matter, as we were discussing about unregistered trademark,
Hmm.
they claim unregistered trademark since 2013. They said even they provided statistics that their Chrome extension has been downloaded millions of times either on Chrome browser or Firefox and
Hmm.
Opera and all the browsers. So they were able to claim common law rights since 2013. And interesting part of this matter was that the other party was being represented by a well-known UDRP panelist, Mr. Adam
Hmm.
Taylor, who has
Okay.
himself given many RDNS decisions. So it was quite a very tough one to fight against a very experienced UDRP panelist.
Hmm.
And but in this matter, my client was also a domain name investor, so we were able to prove that to him one tab meant one tablet. That is, it was more to him related to the medical terminology, one tablet, and it has nothing to do with uh, tab as that is in a browser. So similar like this one tab like we were discussing uh, just few minutes back that if someone can come up with a term independently, so this could be one of those example. Like
Hmm.
tab could mean many things, not only a tab in a
Hmm.
browser. Tab could be short for this medicine tablet,
Yeah.
then it could be a
Newspapers.
tablet computer,
Yeah. Newspapers are also called tablets.
tabloid newspapers,
Hmm.
then tab key
Hmm.
on our computer. So there are
Hmm.
so many references that we could make in our response. And also, luckily, he did register one more domain name that was medagent.com.
Hmm.
Medagent, med short for medicine. So that
Hmm.
also related to medicine or pharmacy field just 2 days before he registered onetype.com. So, due to these factors, we were able to prove that we were acting in good faith. Otherwise, one thing that controversy happened in this matter was this domain name was listed for sale for around 20 to 25,000, maybe 25,000 USD on some
Hmm.
platform. But when this company approached my client for the purchase of the domain name, he raised this price uh, to a higher level. So this was being taken by the panelists that something is wrong there. because when you do a due diligence, a search on Google for one tab, you will there are always some references to this Chrome extension.
Hmm.
So he said that maybe this person raised the prices because after an offer was made to him, he do did some Google searches and find out it is some owner of a Chrome extension that is well known. That's why he raised the prices. So this is a good lesson for any domain name investor. You should be a little cautious. You should, once you have received an offer, if you are not sure from whom you have received, it's better to stick to that price, not try to revise the price, which may go against you in a UDRP proceedings.
How can revising the price go against you?
See, there was some kind of presumption that even this decision reads, if you go through the decision, uh,
Hmm.
what this panelist concluded, he said that when this offers were received by my client, then maybe he did some Google search or find out more about my uh, about the
Hmm.
trademark holder. Then he revised the price, thinking that he is a well-known trademark holder. He has more capacity to pay. So it was a
Hmm.
kind of assumption only. That's why we were able to
But
successfully defend the
but
matter. But he tried.
if I can prove that the domain was registered in the good faith, what
Yeah.
happens later? Does it also matter?
No, yeah, that's what also helped in that matter because we were able
Hmm.
to prove that we had registered this domain name based
Hmm.
upon medical terminology,
Yeah,
not
so
based upon
registered
the
in the good
tab.
faith,
So it
but
was in good faith, so it
then you can
helps.
take your stance in the future, right? Can't you?
Yes, of
You
course,
can
of
raise
course.
prices, you can decrease prices, you can then change your mind and make it available for sale.
Yes, of course, of course. And even these two matters that I have referred,
Hmm.
gonzo.com and onetap.com, as on date, when I visit these URLs, now these are owned, even the trademark owners lost this, both the UDRPs, and we were able to win this. But as on date, they own this domain name. So I assume that there have been sale of the domain name that has taken subsequent to these UDRP proceedings. Yeah.
If you have registered the domain originally in good faith, for example,
Yes.
recently after the advent of AI,
Yeah.
a company called Cursor, which provides software AI for coders, okay,
Okay.
programmers.
Okay.
The software is called Cursor AI. So they purchased the domain cursor.com for like $400,000 recently,
Okay.
in last 1 year or something. Uh, the domain, the holder of that domain, if he registered the domain in good faith, because that company appeared only in last couple of years, he registered
Right.
the domain in good faith, then can he bully the corporation that wants the domain,
Yeah, it also happens
like
even
putting a price of $50 million or something?
means some kind of pressure is always can be created by a trademark holder in a
Hmm.
bid to take the domain name. Like I
Hmm.
remember there was a matter of gosecure.com that happened in the year 2021. So my client was holding the domain name since 2002, and this other Canadian-based Go Secure company came into existence a year later, right?
Hmm.
But they were so desperate to take the domain name that during the proceeding they used to make us an offers, and
Hmm.
we never accepted it. Then even after we got an RDNS decision, they still took my client to the US court,
Hmm.
trying to pressurize him to transfer the domain name. So it happens. These trademark holders, depending upon how much powerful they are, they can always
Hmm.
create different kind of pressures on the domain name registrant to take away the domain name.
Okay, I've read your article on LinkedIn about Indian complainants filing UDRP matters without much success. So, what's wrong with the Indian trademark holders?
Yeah, so specifically, I had written this article uh, a month back when there was a decision in the matter of ecart.com. Like everyone is aware what is ecart, the brand ecart in India. That is a logistic
Cart as in
company.
CART, right?
Yeah.
So cart as in KART, like in
Yes,
Flipkart.
yes, yes, very right. So that is e-cart is the logistic part of the Flipkart only,
Flipkart.
right?
Yes.
So they came into existence in the year 2009, and
Mm.
this ecart.com domain name is registered since year 1998. Yeah, 30th or 31st December 1998. So
Mm.
my main point is, even in this article, my opening line is that does Reliance company owns Reliance.com? So that is a very basic thing to understand, that only because you are a well-known brand, you cannot own the matching.com, because the dot coms came into being 2 to 3 decades back, and if it those are based upon common phrases or common words, as on date you cannot make claim to such domain names. So what is happening is that these Indian companies, I am not sure why they are not understanding the basic law. In this case of e-card, they filed it a UDRP and even got an RDNS GCN, even though it was registered 10 years before they came into existence. Then this Times Group, the well-known Times of India group, that is Bennett and Coleman, one after another, they are filing UDRPs. Uh, just 2 3 days back, they lost the UDRP as they made a claim over the domain name etnow.com.
Mm.
ET stands for Economic Times. They use it very commonly in India. ET now, they even have it trademarked since 1990s. But ET now was .com is being used by a company in Europe, and
Mm.
it is in active use. And they say for us it is entertainment now. So it is,
Mm.
anyone can make any use of the domain name, right? So and later now this week they have filed a UDRP over timesnow.com, this Bennett Coleman, when timesnow.com is owned by a UK based media company. That group is also a media company, though those people also use this term times. So
Mm.
you cannot go after such domain that were registered 10 years, 20 years, or 25 years back. You cannot now, as on date, go after this domain name. And interestingly, in INDRP, this Bennett and Coleman had filed during the COVID time. In Feb 2020, they had already filed a INDRP over the domain name enow.in. So the
Mm.
same lawyer was there. I had defended that matter, enow.in, for a Jaipur-based client. And there also it was established that because it is a combination of such a common term e plus now, so they cannot lay claim to such a domain name, but still they are
Mm.
filing. So some people are really like, I think the owner of Domain Investing also made a tweet yesterday. So people are openly criticizing that why such UDRPs are being filed. Yeah, also this week there was a decision in Nalli Financial Services. Nalli is silk sarees based in, that is a famous brand in South India, but Nalli is also
Mm.
last name for many individuals around the world. So someone who
Mm.
is named as Nalli, they registered a domain name Nalli Financial Services. So they went after this domain name and got an IDNS only 2 3 days back. So there is something
Mm.
really wrong with Indian companies. They are creating a bad name for themselves by filing such matters again and again. That I feel so.
So is it happening more often these days? Something
Yes,
has
of
changed.
we have seen two decisions within the last 3 days only. So of course,
Mm.
and then they also filed times now, so it is quite common. Even eCard, Flipkart is not a small company that they do not have a proper legal advisor that what to do or not to do. Yeah,
Mm. Okay. So we have covered all the viewer questions. We can wait 5 more minutes if some viewer has a question.
yeah,
We
sure.
have covered all of them. Right. So are you a domain investor yourself?
Not exactly, though I have some few
Hmm.
legal domain names I have kept that I like IP lawyer, trademark lawyer.in,
Hmm.
that I keep it that I may use in near future. Yeah.
Okay.
Yeah.
And Guru, blog.guru, you own that domain also, right?
Yes, yes. Yeah, that is also a
That
blog there.
used to be your blog, which is not active anymore.
Okay, it is not dissolving the domain name?
Domain blog is resolving. By
Resolving, fine,
active, I
fine.
mean
Yeah, it
by
is not
active, I mean
active.
you are
Right,
not
right.
posting
That's,
anything.
yeah, I am not posting anything there.
Yeah, you are
Very
not
right.
posting
Yeah.
anything.
Yes, yes.
Okay, so
I think there is question in the comments like someone is asking, will first name, last name will come under trademark issue? So yes,
yeah, I
we have
don't think so.
seen, yeah, so
Hmm.
like we have seen many domain name investors uh, registering exact matched domain name that match exactly to some first name and last name combination. So
Hmm.
now it depends. What happens is under UDRP, a person can come to claim over to make a claim over a personal name only if he is able to prove that he has rights in that name as a
Hmm.
uh, not as a even as a trademark but unregistered rights we can say. For
Hmm.
example, a person who is a celebrity, say a
Hmm.
singer, a sport person, these persons are more easily be able to prove common law rights in their name and come under UDRP
Hmm.
because such names are used in a commercial sense, right?
Hmm.
But a person who say is a director in a company, even if a company is well known, but if that person names is not being used in a
Hmm.
commercial sense, then that person cannot come against you at least in a UDRP. Though the civil
Hmm.
law and other court thing is there, but those people will not able be able to come under a UDRP.
Hmm. So big celebrity names like Shah Rukh Khan or A.R. Rahman or Virat Kohli.
Yes. Yeah.
So they are as much of they have much brand equity just like a company name.
Yes.
So they
Yes.
are
Yes.
treated the same.
Like Mr. Rodney Ryder only filed a complaint for msdhoni.com. It was
Oh,
5 to 6 years back. So they
so
were
they
able
have
to
brand
successfully
equity
get
just
the
the same.
transfer.
Hmm,
Yeah.
I can understand.
So such celebrities can easily prove rights in such names. Yeah.
Hmm. Okay. I think there is one more viewer question. Can anyone go for jail for registering a domain? Please tell.
So not exactly like if it is a civil matter and it is a trademark
You can
infringement.
go to the extreme for this question. The question is, can someone go to the jail for a domain registration?
Yeah, I'm coming to the second part. So
Hmm.
initially, like for a trademark infringement, mostly there will not be any such issue. But of course, like there could be if their domain name is used in some kind of scam or kind of phishing or
Hmm.
some kind of criminal activity, you are selling duplicate products. Like we see well-known brands, second products are being sold, like it may be clothing or perfumes or any kind of that are not real. Then if such complaint goes to the court, then of course the criminal proceedings can also come against the domain name registrant.
Hmm.
Yeah.
So unless you are not making a website on it, just for registering the domain, it's not much harm.
Yeah, no,
But you
only if you
cannot
are
get
making
into domain.
active use, only if you are making some uh, illegal use of the domain name. Yeah. I think
Okay.
there is another question before that also.
Hmm. I have a unique domain name. My feed is not refreshed, so I'm not seeing the latest questions.
Okay, it said does have a unique domain name means having
We
the
have
right
covered
one.
this question.
Okay, we have. Okay, fine.
Hmm. Do you still play chess?
Yes, sometimes
Any
online only at
final?
chess.com.
Okay, chess.com, a great domain, right?
Yeah, yeah, definitely.
So, okay, I think it's time we should wrap up.
Right, right.
Thank you everyone for joining us. We had some like 13, 14 viewers all the time. Stick to the screen. We have also received 15 likes, and that is encouraging enough. Thank you, Mr. Raheja, for joining
Fine.
us.
Yeah,
And
thanks to you as
it
well.
was, yeah, it was a great experience talking to you. And many of the questions were my own.
Right.
I had a lot to learn from you. And we hadn't talked, even though we are from the same city, we haven't talked much in lately. So it was a good experience again.
Yeah. Yeah, the
Okay,
questions were
bye.
quite interesting, really.
Yeah.
Thanks.
Do
Thanks a
you
lot.
want to give some advice as a parting advice to the new domain investors?
So, like a few things that we discussed, so if you are a domain name investor, as on date, there's nothing to hide. Yeah, only the thing is, if you are holding a dot in domain name and it is not a dot com, then the domain name investing is something that is to be hidden because there are not good precedents under INDRP. Though
Hmm.
in one of the matter tickets.in, I myself was a arbitrator, so I had uh, provided that there is a difference between cyber squatting and domain name investing and all such in detail. But still, nothing is being followed. Even later, we had there was a INDRP over three-letter dot in domain name, which was transferred away. Though my client was holding that domain name since 2005, and the other company came into India only in 2018 or 19. So there are not good precedents. So if you are have a dot in or CT Indian CCTLDs, so it's better first check that how safe your domain name is.
Hmm.
Like someone was having Navratan.in. So Navratan, otherwise Imami is using it for a selling brand name, a well-known
Hmm.
brand name that is well-known for last many
Hmm.
decades. So
Hmm.
depending upon how big brand is using a similar phrase as a trademark, you should put it on sale or avoid it. So some homework you must do before putting .in domain names on sale. At least Google it that someone well-known brand name is not using a similar domain, similar brand name.
Okay.
Yeah, that is
So if,
important.
if someone wants to take your services, how can he find you?
Yeah, I am available on LinkedIn. Yeah, you can search for my domain, my name on LinkedIn.
Hmm.
Yeah,
And your website is cylaw.in. CYLAW.
websites are not that active.
Okay.
Websites are not because
So LinkedIn,
even the
LinkedIn is the best
domain,
way.
even
Okay.
my domain name, domainlawyer.in redirects you to my LinkedIn page. That is the
Good enough.
best
So
place.
LinkedIn is the
Yeah.
best way to contact you.
Yes, yes.
Sure.
Yeah.
Okay. Bye, everyone.
Fine.
Good night.
Thank you. Thanks a lot.
Thank you, sir. How to end it?